Hello. No, come on, cut this. Ella. Ike now. Don't say best me because of my sister. So we are just small so that. Should I hold you the record? You're taller than the taller. She's not supposed to give you. You're taller than her. She's not supposed to give you just balance your hands. Can you move forward? Could you? Give me. Well, you will recall that on the last agenda. Go ahead. Okay, sir. You will all recall that on the last adjourned date, we moved an application seeking for the discharge of the defendant on all the counts, the 15 counts filed against the defendant. And the court, in its wisdom, now reviewed all the charges and discovered that with the exception of 7 counts, about 8 counts appear to be similar, and those charges were struck out. Now, it would be also understood that in the argument of the defendant, the account that is reflected in the charges, when you go to the charge, you get to know all the counts. But all the counts relating to terrorism are really sustained by the court. And they make heavy weather on the issue of rendition, and the court bluntly said that rendition in this situation is allowed, because rendition in criminal law, in criminal case, is allowed. After all, the defendant is under a bench warrant, and anywhere he is seen, the law allows him to be taken and be forcefully brought to court, and that was what exactly happened. And again, with respect to membership of IPOB, which he denied, it was the argument of the defendant that the matter is on appeal on whether IPOB is a proscribed organization under the Nigerian law or not. The court also emphatically said even though the issue is on appeal, but what is in place is that IPOB still remains a terrorist organization within the confine of Nigerian law. And immediately thereafter, they moved another application for bail again, which the court ordered that such application be taken, and arguments were proffered. And it was also in their argument that Nnamdi Kanu had never flouted any of the conditions of the bail. And we have argued vehemently, showing to the world, showing to the court that he has actually flouted all the bail conditions. And that was the reason why the court has ordered for his, revoked his bail and ordered for his arrest. And it was also our argument that what we should be talking about is contempt of court, not even issue of bail anymore. And we are awaiting the response of the court on the next adjourned date, which the case is now adjourned till the 17th, 18th, and 26th of May 2022 for ruling and continuation of hearing. But one thing that is very significant that I thought I should mention here is that the court has already hinted us that arising from the new practice direction, considering the inconvenience this case has always caused other courts within the premises and other offices within the premises, moving forward, this case will be heard in other places that will be communicated to parties before the next adjourned date. This, I thought, is very important, and I thought I should let you know.
Sir, journalists were today, accredited journalists were barred from gaining access into the courtroom. What's the position of the prosecution on this? We've just afforded you the platform to tell Nigerians what transpired in the courtroom, and we're not allowed to go into the courtroom.
Well, I think with respect to that, that will be the business of the information unit of the Federal High Court. I am to give you what actually transpired in the court. So I'm afraid I will not be able to respond to that.
What about the jurisdiction that
Well, the issue of jurisdiction, already the court has already sustained that. Refused that issue of jurisdiction. This court has the jurisdiction to entertain this matter, and that is the more reason why this matter will continue with the remaining 7 counts against the defendant.
What's your name, sir?
My name is...
Victory in the true essence. Victory by the grace of God. Victory because according to Lamentations 3:37. Rhetorically, the Bible asks, who is it that speaketh, and it cometh to pass, if God has not commanded it? The question of this counts and the eventual question of the entire counts by the grace of God will be by the grace of God, because he's seated on the throne, because he is awesome, because he is marvelous, because he created but he was not created, because he is the unmoved mover who himself was not moved, because he is the ancient of days, the Alpha and Omega, the beginning and the end, the first and the last. That it is that same God that delivered Paul and Silas in Acts of the Apostles chapter 16 that is with us on this case. That same God that delivered Daniel from the jaws of the lions is with us on this case. That same God that delivered Meshach, Shadrach, and Abednego from the furnace of fire is still with us. That same God that delivered Lazarus after 4 days of his burial, when he was already rotting, that delivered him from the grave and he walked, he's still alive. That same God that delivered Jonah from the belly of the fish, where he was, and deposited on the shores of Nineveh, is still alive. That same God of Jesus Christ that rose from the grave, from the tomb, the 3rd day after he was buried, is still alive and is active in this case. So today, 8 of the 15 count charge were quashed and dismissed, leaving 7 counts that are on wobbling legs, counts that wobble, counts that are groggling, counts that fumble, counts that dwaddle. They will not stand. They will not hold water. Because you cannot build something upon nothing and expect it to stay. It is not possible. If 8 counts went, the remaining 7, as a necessary corollary, we go. It follows as the night, the day, as the rainy season, the dry season. It follows. The 7 counts remaining, we go. But when we look at those 7 counts, whether they even hold any water at all in law, we'll be able to refer to the case of FRN versus Saraki, where some counts were quashed by the Code of Conduct Tribunal and left some. Quashed all, and then the Court of Appeal decided to quash some and left some. And the Supreme Court said, this is not possible. If you quashed A, B, C, D, the other ones that are also related to it by affinity, by consanguinity, they should also be quashed. That was how Saraki got free. So we will test this remaining count charge. Let the prosecution get that notice at the appellate court. There are many. There are 8. So today, after the counts were quashed, particularly counts 1, 2, 3, 4, 5, 8, and 15, they were quashed. Right. Those are the ones that are remaining. The other ones were quashed.
6, 7, 8, 9.
So we then proceeded to move our bail application that the defendant, Mazi Nnamdi Kanu, deserves to be granted bail. The case of the prosecution has always been, and this is sheer falsehood, that Nnamdi Kanu jumped bail, and that was why he was forcibly renditioned back to Nigeria. A rendition which the court did not agree with us today, which we shall test, that is contrary to provisions of the African Charter on Human and People's Rights, contrary to the Universal Declaration of Human Rights of 1948, contrary to the International Covenant on Social and Political Rights, contrary to the instrument dealing with indigenous people's rights. When you have a treaty with a country such as Nigeria with Kenya, and a person voluntarily entered Kenya, and you renditioned him forcefully through torture, inhuman and degrading treatment back to Nigeria on the 27th of June 2021. All the cases based on my research across the world show that such a person cannot be tried. Cannot be tried at all. Based on that first original sin, the type of original sin committed by Adam and Eve in the Garden of Eden when they ate of the forbidden fruit. You cannot try such a person. We will try this one. That he jumped bail? The answer is no. Nnamdi Kanu was enjoying his bail. He was within Nigeria. He never left for abroad. Then on the 14th of September 2017, the military went in armored trucks as if they were going to war in Sambisa forest and invaded the home of Nnamdi Kanu and his father, His Royal Majesty Kanu, who is now late. Invaded him brutally, savagely, and mowed down 28 innocent Nigerians that were there without cause. They called it Operation Python Dance and other operations. We've not seen Operation Python Dance in Sambisa Forest and Chibok and Dapchi. They murdered 28 innocent Nigerians in cold blood. Somehow, Nnamdi Kanu, like the cat with proverbial 9 lives, he was able to escape. Are you saying that a person who was to be killed and ran away from certain death jumped bail? The answer is no. It was late Chief Emko Abiola who made that statement. He said, they said I should have waited for Abuja. They were asking me, why did you run abroad? Why did you fly abroad? I'm telling you now, Tony and Neni, I'm now telling you, I was already in the air before I discovered that even my passport was not with me. A bird does not tell another bird that a stone is coming. It simply flies away. No man stands in front of a moving train and expects to leave. He will be crushed. So you are saying Nnamdi Kanu, after escaping barely with his life, should wait in Nigeria. If he had been killed, he wouldn't be standing trial here. So he did not jump bail. Rather, they forced him into exile. And he went as a citizen of Britain to Kenya, where he was forcefully and forcibly under torture, inhuman and degrading treatment, renditioned back to Nigeria. So this is a case deserving of bail. And we implored my Lord to grant him bail, even if she wants to subject it to certain conditions, let me tell you, even under the Administration of Criminal Justice Act, bail is allowed. It's discretionary. It's allowed even in capital offenses like murder, like treason. And mind you, Nnamdi Kanu is not standing trial for treason. No. It's very important. We all have to hear this. Nnamdi Kanu is not standing trial for treason. At all. He's standing trial for offenses relating to treasonable felony, but not treason itself. For example, there's a difference between saying the person is standing trial for murder and standing trial for manslaughter. They are different. One carries capital punishment. Nnamdi Kanu is not standing trial for any capital punishment. But the Administration of Criminal Justice Act still says, even in capital offenses, an accused person can be granted bail, subject to the discretion of the court. And do you know why this has become more necessary? Section 36 of the Constitution has given every Nigerian the right to fair hearing. And fair hearing, like I told the court, also means a fair trial. A fair trial includes all the circumstances surrounding a case. That is Section 36. Because our criminal justice system is the Anglo-Saxon-based criminal justice system. It is accusatorial. It is not inquisitorial. What does this mean? It means that it is the innocence of a person and not his guilt that is presumed. It is different from the French model, which is inquisitorial, wherein your innocence, your guilt is presumed, and you are told to prove your innocence. We are not operating that. And that is why Section 36 of the Constitution puts it there clearly, that you have to prove the offense against a person. And the Evidence Act goes further to say you must prove it beyond reasonable doubt. Any doubt, no matter how small, even if it's like that little straw that broke the camel's back, will be resolved in favor of the accused person. So, Nnamdi Kanu, therefore, is entitled to be subject to the court's discretion and imposition of certain conditions, because we have shown that he did not jump bail. He almost got killed. That was why he ran away. So we believe that this is a proper case for the court to grant bail so that Nnamdi Kanu will be alive to stand trial. That is why in law we say come and stand trial. Come and stand trial means you have to be well, hale and hearty to stand trial. He didn't say come and sit down trial, or come and lie down trial, or come and prostrate trial, or come and be in the grave trial, or come and be in the hospital trial. He says, come and stand trial. And can we say there's a fair trial when in our bail application, Nnamdi Kanu is complaining of solitary confinement? That is not allowed. He's only brought out maybe once in a week to receive vitamin D, the sun. And that when he comes out, by other prisoners or prison inmates or detainees merely greeting him, such detainees are subjected to harrowing experience. They themselves are moved to solitary confinement as punishment for exchanging views or greetings with Nnamdi Kanu. Is that a fair trial? He says that he's not allowed to practice his Jewish religion. He says his health is deteriorating fast. His potassium level, his sugar level, his blood pressure, his heart issues. He says he needs his private doctor to give a second opinion, but they are not allowing it. We, the lawyers, are not being allowed. The judge was again forced today to make another order, ex abundante cautela, for the avoidance of doubt again today, that the clothes they are brought here now in fact, he should now take them with him to DSS headquarters. Do you know why? Because 19 times between February 21, 2022, and this week, 19 times, The lawyers and family members are taking this close to him, and the DSS refused. I personally led the lawyers on 3 occasions. Can you say that's a fair trial? If I carry a bulky file, you must drop the file. My wristwatch, my ring, only my ring they allowed me last time to steal. My wristwatch is removed. All my biro, my reading glass, even my handkerchief, made in China. You know we don't make anything here, not even handkerchief. Made in China. Look at them. Made in China and Hong Kong. They even took this handkerchief. Can you say that's a fair trial where a lawyer cannot confer freely with his client? And of course, the little space one will give it to us to confer. You don't need to be told that it is all bugged. It is gadgets. Is that a fair trial? So when I'm discussing strategy and a case with my client, then my opponent, the prosecution, the state, with all its federal power level, apparatus, should be listening to my conversation. Then when I go, you put it on and say, look at these idiots. Look at what they were saying. Is that a fair trial when you eavesdrop on me? So, what kind of criminal justice are we operating? That the person who unlawfully abducted a person, the accused, back from Kenya on the 27th of June 2021, under torture. Of Nigeria is the one that is also having custody of this same person. So, head or tail, they are winning. So, where is the justice of the matter? Where is the fair trial? Where is the level playing ground? That is why we implored my Lord this afternoon, genuflectingly, to kindly admit Nnamdi Kanu to bail, so that he will not die. I've had some clients who were standing trial. I begged some courts like this to grant them bail. I don't want to mention one of them. He was still undergoing trial and he dropped dead. The next time the case came up, I made sure I was in court. I asked the prosecution. I don't want to also mention his name. I said, we are here now. Where is the subject matter of trial? He said, Chief, you should know better. I said, I don't know anything. Why? What do you mean? He said, he's dead. I said, oh, he's dead. I said, so what's the effect of that? He said, that means the case has terminated. I said, oh, why don't you try his corpse from the grave? Try his corpse from the grave. Of course, that was the end of that matter. But that, my client was not allowed to be able to show that he was innocent because the prosecution couldn't prove the matter. Under a name and shame government, name them and shame them, just accuse them of crimes, even when we can't prove it, what you call media trial, outrageous, atrocious. Then you carry those accusations, those allegations into the grave with you. The people have families, they have friends, they have associates, they have community people. That is not fair. So that was why I implored the court to grant us it. By the grace of God, we had a wonderful outing, and God is on the throne, and will forever be on the throne.
Thank you, sir.
Amen. Thank you.
Thank you so much.
Are you guys ready?
Yes,
So the Federal High Court just issued new practice directions, and it includes that the terrorism trial will now be done in camera.
And that affected us from entering the courtroom today.
Yeah, I do not believe in secret trials because Section 36 of the Constitution talks about open trial. But the point is appreciated that each day this matter comes up, other courts are closed down and that other litigants are not allowed to have their day in the market. I'm fair-minded enough to know that a system that does not allow other litigants to have their day in the court just because of one litigant cannot be said to be fair. I'm a human rights activist and constitutional lawyer. I know that my conscience, also as a Christian, does not agree with that. But there are areas in the new practice directions that I quarrel with. In other words, I do not mind if they move the venue to another place that does not disturb other litigants and clients and witnesses and other. But I'm worried about one provision that screens off journalists in the media, the fourth estate of the realm, under section 22 of the Constitution. Because if you stifle information, the wrong information can emanate from the rumor mill, and that is a more dangerous issue. The Supreme Court says so, and I think that was in the case of Adesanya versus President of the Senate. If you stifle information, then the rumor mill will become very active, and things will begin to germinate. We have a proverb in my home, in my language. I'm from Ivukwe, near Agenebode. It's called East Local Government Area of Edo State. The proverb is Ono ayoela zavuyuko lo hazo mo agule. What does it mean? He who was not present when a fat he-goat was butchered will argue later that a fetus must have been removed from his tummy after it had a big tummy. In other words, seeing is believing. You don't hide information. So when you prevent the media from covering a trial, then it may lead to generation within the rumor mill of things that never happened, which again jeopardizes the fair trial of an accused person, even of the prosecutor and even of the judiciary itself. In terms of witnesses attending, I have no problem with witnesses being screened off. That is good to safeguard the interests of the witnesses and the fact that you refer to them as A or B instead of by their names. That safeguards them. That is a very wise decision. Safeguard witnesses, screen them off. Or if you want to use Zoom, fine. Although that is subject to whether, when you use Zoom, whether cross-examination can also be allowed in that method, or whether the court can be said to watch the demeanor of the witness. But I am I'm not therefore much against the issue of shifting the venue to a more convenient place. That is fair enough. I'm not against the issue of screening of witnesses. That is fair enough. But I'm against the issue of making it look like a secret trial, as if a trial is like a gathering of witches and wizards in a coven. It should be a public trial which the whole world can watch. Then when you come here, you can screen out the people and decide on how many people can attend, the same way we have been doing it. I believe that. Because of that, by the grace of God, I'm going to challenge some portions of the new practice directions as being unconstitutional and against so many sections of the Constitution of Nigeria, which is the ground norm of the Nigerian law, which I've referred to at different fora as the Oba, the Eze, and the Emir of Nigerian laws in the hierarchy of laws, the ground norm, the Fonds 8 Origo. We will challenge those sections.
Thank you.
Thanks for checking out SYMFONI on YouTube. Please be sure to subscribe and like our videos for updates.